Good morning, everyone. We have with us
Namaskar, sir.
Sri Gadhar Panda sir, who is a retired district judge having 30 plus years of experience in Odisha judiciary. We also have with us as our second panelist Sri Prabhu Prasanna Behera sir, who is a central government counsel for the government of India and has also 15 plus years of practice experience. Sir will take the interview as the first panelist, Gadar sir, and Prabhu sir will be the second panelist. Likewise, feedback will be given. Also, one thing, Sudatta, there is some disturbance with your network. You are in a very noisy place. Can you reduce the noise a bit? Fan or
Sir,
something is on?
no, sir, nothing is on.
There is a constant noise coming. Can you please check what it is? What is it?
Yes, sir. Sir, is it okay now?
Okay. Okay. What's your good name?
My name is Sudatta Panigrahi, and I've
Okay.
completed
Okay. What is the compounding of an offense?
Section 320 of Criminal Procedure Code talks about compoundable offences. There are a list of offences which are provided in which there can be a compromise if it falls under those category and the result of compounding of offence results into acquittal.
Who will compound? Whether the at the instance of victim is dead, who will compound the offense? If in a case when victim is dead,
In
compounding
case
is
of
always
the
made with the victim and the accused.
so
If the victim is dead,
in
okay.
case if the person is sick or infirm, in that case or less than 18 years of age, the legal representatives can do, and the other
Whether
one I
compounding offense can be claimed under law that it must be compounded. But is came to the court and intend to compound a particular offense as it is mentioned in section 320. And whether the
if
court can refuse.
court can refuse only if it is not provided under section 320. The offences, if it is not provided under section 320, it won't allow. However, if the offences are provided under section 320, then it's the duty of the court.
What is commitment of a case?
Generally, honorable sessions courts don't have power to try the case in their original jurisdiction. In those cases, the judicial magistrate, if he feels that there is a sufficient material that has to be placed before the honorable court of sessions, in that case, commitment is done.
What is summary trial? Which
Summary.
judicial officers are competent to try summary?
They are the Judicial Magistrate First Class, Chief Judicial Magistrate, and Metropolitan Magistrate. Judicial Magistrate Second Class can do if the High Court permits him to do.
What procedure is to be followed in summary trial?
It's the summons procedure that is followed. However, the amount of punishment is that of 3 months. Like maximum amount of punishment that can be awarded is of 3 months.
Can there be a telephonic affair?
Yes, there can be. However, he has to disclose that there has been a cognizable offense.
Which cases, which offences a second class judicial magistrate can try?
Uh, the cases in which the fine amount is less than is 5,000, or the amount of the quantum of imprisonment is 1 year or less than that.
So in all cases, the second class judicial magistrate can try. Whenever a fine punishable with 1 year or 5,000.
The jurisdiction that I can remember is of that much. However, I don't know whether it's a hard and fast rule.
A person came to the magistrate and made an oral complaint that so and so committed theft from my house. Whether magistrate will take cognizance of the offence basing on oral complaint made by the person.
Um, by by virtue of section 200, he will examine the complainant and the witness. If he feels that there is sufficient ground, then he will reduce it to writing because it is given as a oral complaint, and thereafter he will sign along with the witness and the person, the complainant. They will sign that complaint that is given.
During inquiry, the magistrate found for the same allegations a police case is pending. There is a case pending in a particular police station. What the magistrate will do?
In that case, you can stay the proceeding and will proceed with the police report.
Proceed with the police report.
Yes, he can.
When there
He
will be a
can.
stay in a suit. Okay.
Uh, he can stay the proceeding if there are two things going simultaneously, but I can't exactly recall that what exact step he will be taking.
What is section 151 of the CPC?
Talks about the inherent right of the civil code.
In which case, or in what circumstances this inherent power of civil court is to be used?
There is as
Or what?
such no hard and There is no hard and fast rule for this. However, if there is a for the interest of the justice, it can exercise its jurisdiction, uh, the inherent power he can use.
What is precept?
Precept is an order that is, um, in case if there is the judgment is given, and the judgment is so that in the favor of the decree holder, and the decree holder he gives an application before the court that so and so property, the person is about to dispose the property, it is located outside the jurisdiction. In case if this honorable court he believes that he will dispose the property and the execution cannot be done, he will issue a precept. It will remain in force for two period of 2 months.
What is the extraterritorial application of that Indian penal code?
It is
Whether
discussed.
in which case the Indian penal code is applicable to a person committing an offence outside India.
In case if a citizen of India is committing an offence outside India, then when he is brought in India, he can be tried under the Indian Penal Code. Or if someone is targeting the resources of the com- targeting the computer resources, in those cases also he will be held liable. To that extent, it extends.
An aircraft of India is at Canada, is in Canada. There one Canada citizen, a person who is having a Canada citizenship, a resident of, he is a Canada person. He entered into the aircraft and committed a murder. Where he is to be tried?
In Canada itself, because the airline is of registered in Canada and he is a citizen of Canada, so IPC won't be applicable to him.
I told the aircraft is of India.
In case if it is of India, then it can be tried in India.
Can he be
If
tried
he's
in Canada?
yes, if the according to their law, because he has committed an offense there, then definitely it can be tried there as well.
Whether a civil court can arrest the defendant.
Yes, there are certain grounds in which he can arrest. However, yes, he can.
The order of the temporary injunction issued by the court that was disobeyed. Then how that order will be enforced?
There is a particular provision. There a particular provision that I don't remember, but sir, um, I, I think that he can be arrested on that ground, and other remedies. I am sorry, sir, I am unable to recollect.
Whether an expert temporary injunction can be granted
Yes, based on the interest of the justice, it can be granted.
only for the interest of justice. In which
Yes.
case?
In case if it would hamper the other party's interest, in those cases, it can be granted. I'm really sorry, sir. I'm exactly unable to recollect.
What is actionable claim?
Sorry, sir. I won't be able to answer this.
What is a mortgage?
Mortgage is basically it's a kind of wherein a person he gives his immovable property in term for the purpose of securing a um, for no, no sir, I'm unable to frame it
What,
correctly.
what is lease?
So lease is a right that is given for a temporary period of enjoyment of the property in return of premium or rent.
Okay. Which a child witness? Whether a child is competent to testify in a case?
Generally, it is seen that whether he is able to understand the questions that is put before him. However, no oath is given to him, and it varies from case to case. He can be a competent witness. However, it is subjected to discretion of the honorable court.
Who is an accomplice?
Accomplice is a person who has taken part in the crime, and later on, if he kind of takes or accepts a tender of pardon, in that case, he becomes the approver, government approver, and becomes the witness of the case, and he appears in on behalf of the state.
Can there be a conviction basing on the testimony of our accomplice?
The general rule, as provided under the section, is yes, but however, it is under section 114 illustration B, which says that and conviction can be based on the testimony of accomplice. However, it is a rule of prudence that it is an kind of a corroborating evidence. It has to be seen that the person the others evidence has also to be taken into account.
The Honorable High Court called for a record of the session laws and exercised the power of revision. Is the Honorable High Court so moto can do so?
Yes, sir, he can.
What is the power of assistant session law? Sentencing
Sir,
power of assistant session.
you cannot pass death, life imprisonment, and sentence for more than 10 years.
Then Any fine? Is there any restriction in
Fine
fine
is
imposing?
no, no, unlimited fine amount.
Unlimited. The
Yes.
assistant session judge sentenced a person with fine of 5 lakh rupees. Is it illegal? 1 year
So,
imprisonment and fine of 5 lakh rupees.
so as such, there is no restriction that is provided in the Criminal Procedure Code. However, the fine does not have under. I'm not sure, really sure about this thing, but the fine should not be unlimited. It should be something that can be recoverable.
Who is an expert?
Expert is a person which is discussed under Section 45. There is no hard and fast rule as to determine as to who is an expert. It varies from case to case, depending on his knowledge in science, in arts, and in foreign law, or in any other aspect. He will be termed as an expert.
What is intestate succession?
Intestate succession is generally when a male or a female Hindu dies. In case if they have not done any testamentary succession, in those cases, it is said the succession that takes place it is an intestate succession.
What is testamentary succession?
In case if he has made any will and he dies, in that case it will be a testamentary succession.
What is will?
Will is a document that is prepared by a person that after his death, so and so person will be taking his property.
If will requires compulsory registration.
Yes, it's probate or something.
What is probate? Will and probate are two different things. What is probate?
It's an authentication by the. I'm really sorry, sir. I'm really sorry.
Right to collect lac from a tree. That was transferred. Whether for that any document is required, lac of worth 20,000. That was transfer. That whether that a document is required to be registered for that transfer.
I'm sorry, sir. I won't be able to answer this.
What is affray?
Sir, affray is basically when two persons they fight in a public and create any sort of disturbance and hamper the peace and tranquility.
What is abduction?
Abduction is whenever there is force, when a person he exercises any force or compels a person to to go from one place to another place. In that case, we say it as an abduction. It is an auxiliary act. It is not a substantive offense and is a continuing offense as well.
Can there be a conviction in rape case based on the sole testimony of the victim?
I'm not really aware about it, sir, but I think yes, it can be. However, mm, some other evidences are also required.
What is dowry death?
Death caused within 7 years of marriage and demand of dowry that is discussed under Section 304B of the Indian Penal Code.
What is transferred malisi?
Transfer of malice is generally discussed under Section 301. In this particular context, even if the person may not have intended to kill the other person, however, he will be held liable For example, if we say that A wanted to kill B, but he kind of missed the chance and he killed C, then he cannot take the plea that I wanted to kill B and I had no mens rea to kill C. Here he will be held liable by virtue of section 301.
A had deer fish in his tank. There was a heavy rain on one day. So those fish came out from the tank. B was going on the road and took 2 to 3 fish from that road. What offense he committed?
Hmm. Uh, I don't have this answer, but I think it's no offense because it has already come on the road. Not very sure about it, sir.
X was selling cucumber by the side of a road. He had displayed a signboard that one cucumber, 1 rupee. X was absent from that place. Y took 10 cucumber, kept a 10 rupee note there and went away. What offense he committed?
I think it's no offense because he has given money in return of it. Um,
What is criminal trespass?
um, with the intention to intimidate, intimidate, annoy someone enters to the possession of another person's property with a criminal intent if he enters. I'm really sorry, sir. I'm unable to recount this thing.
What is rioting?
Rioting is when an unlawful assembly it uses force and violence, then we call it as rioting.
Okay, I'll give you my feedback after the interview of the second panelist.
Yes, sir. Namaskar, sir.
Namaskar. How are you?
I'm good, sir.
Good. You are satisfied with your preparation,
Hmm.
or you feel
I,
that anything else has left, or you need to prepare more?
I think, sir, I need to revise a little bit more. I'm not doing it nicely.
Okay. Okay. So suppose, what is your second option? Suppose you are not going to join judiciary. Even if you qualify, you decide not, or some other thing happened, you do not join. What is there any option in your mind that without joining as a judicial officer, anything else you would be best doing at?
So, with the knowledge that I have tried to gain in this period of time, I think I could do well with respect to academic, and that isn't teaching or something. If I can just give net or
So if you'll teach, then which subject is your favorite subject?
maybe I'll try for criminal law.
Okay, in a criminal law. Okay. So there is something called mens rea and actus reus in criminal law.
Yes, sir.
Okay. What are they and what is the importance of these two terms?
Mens rea is the mental element, and actus reus is the act that has been done. They both are very important. However, it is subjected to exception. Like mens rea, it is not taken into consideration when the offence is regarding food adulteration or counterfeiting coins, or with respect to offences that is committed against state. Generally, they both goes hand in hand in terms of in term of constituting a crime.
So in a criminal trial, suppose A files an FIR against
Mm.
B. B is prosecuted under the criminal law before the magistrate's court or a sessions court. Then the state comes to uh, picture as a prosecution, right?
Yes,
But
yes.
it is not the complainant or the informant who has filed the FIR, right? Why the
Hmm.
state uh, states plays the role of prosecution?
So the main idea behind is that crime is not against only the individual, but it is against the whole state. Like if if any serious offense happens in one place, then it creates a fear, or the mind gets really disturbed that some offense has happened. So that's why it's the responsibility of the state. That's why they kind of represent the prosecution side.
Now, is there any legal definition for state?
Yes, it is dealt under Article um, 12 of the Constitution of India.
Okay, so what is the definition?
Um, Sir, state actually encapsulates a very big term. It contains the local authority, the government authorities, and the other authorities which are under the deep pervasive control of the state in itself.
Okay, so you want to file a suit against, let's say, the local municipal corporation
Hmm.
for injuncting them to do something. Okay, so will it be considered as a suit against the state,
Uh, Against the municipality authority?
municipal
Yes,
corporation? Yes.
yes.
Okay, so what is the basic requirement that this has to be done? Then only you can file a suit against the state.
Prior 2 months of notice is given. However, it is not to be taken
Notice under which provision?
under Section 80 of the Civil Procedure Code in case of when one wants to institute a suit against the government, or one wants to institute a suit against any authority who is acting in that public capacity. In those cases, 2 months prior notice has to be given. And if at all the competent authority kind of solves the issue, then the suit can be taken directly to the
Okay. So, do you have any idea about acknowledging the acknowledgement of liability?
Yes, it is discussed under the specific relief act. It kind of just extends the period
Which
of
provision?
limitation.
Can you say
Provision,
the provision of specific relief act?
sir, I am not very sure, but it's under 17 or 17, 18, 19, I think deals with acknowledgement.
Just make a note and verify. All right.
Yes, sir.
Uh, okay. Have you got any idea about dispensing the personal appearance in a criminal court after receiving the summon?
Yes, in case of petty offences, he can the attendance
Is
of
there any
the.
provision for dispensing the personal appearance of the accused?
So there is a provision, but I am unable to recollect the exact provision. But yes, it is there.
In the first round, I mean, when sir was asking you, you mentioned two times about police report.
Hmm.
Right? What do you mean by police report?
So once the investigation is completed by the police, he submits a report that we term it as police report.
Is there any difference between a police report and a charge sheet?
No,
Okay.
I'm not
Then
really
which
sure. Sir.
provision? Okay, okay, all right. Which under which provision of law a charge sheet or a final form is submitted by the police?
Sir, under section 173 or 174, I'm really not very sure about the provision.
So are you asking me to answer it?
No, no, sir. I don't know this about this answer.
Okay, okay. All right. Wish you all
Okay,
the
sir.
best.
Thank you, sir.
Okay, I want to give you some feedback in the matter. First case, compounding. Some offences are to be compounded with permission of the court. Without permission of the court, some offences are to be compounded. So when permission of the court is required, in such case, the discussion is with the court, either to permit for compounding or not. It will not be. But when it is compoundable without the permission of the court, that can be compounded. Court cannot refuse. Section 209 IPC that will commitment when the magistrate will commit the case, when that is exclusively triable by the court of session. Complying the provisions, whether police papers have been copies of the police papers have been received or not, then as per the requirement of section 209, the case will be committed. Summary trial, I put a question that is summary trial can be made only certain category will be who are the empowered. Chief Judicial Magistrate, Master First Class, is second class magistrate if empowered by the High Court can conduct summary trial. Certain categories of offences as mentioned in the section, those offences only can be tried. That summary trial summons procedure is to be followed. Then that is ex parte injunction can be granted when the purpose of injunction will be defeated. This is very important. Only in such case when the purpose of temporary injunction will be defeated unless it is granted ex parte, then only ex parte injunction, temporary injunction can be following all the requirements of the law. Then action on claim to any debt other than debt secured by mortgage or hypothecation property, which the civil court recognizes as a ground to give relief. Mortgage, on the other day, I had also told you what is mortgage. Mortgage is a transfer of an interest always in a specific immovable property for payment of money. Security for payment of money by either as loan advance. Please, this is a transfer of a right to enjoy that you are committing. Other day also transfer of right to enjoy certain movable property for certain period in lieu of payment of rent, periodical payment of rent, or in a lump sum money is paid price that is called free. Child is competent only before taking a child because every person is competent to testify unless by tender age, old age, or by sickness, unable to understand the question put to him, or to give rational, something like and, not and, or to give rational answer. Then accomplice who has taken any part in the commission of the crime is going to accomplish. Accomplice evidence is that there are two provisions in the Indian Evidence Act. Accomplice is not unworthy of credit, but section 114 there should be accomplice only. That 133 there is a provision, accomplice evidence is competent, then it is not illegal if a conviction is recorded. But however in section 114, accomplice is unworthy of credit. So that is a some amount of corroboration is required to the accomplice evidence to record a complaint. Then Honorable High Court has the power to call for the records of any inferior criminal court in order to satisfy itself legality, correctness, legality of any finding sentence. That is it. Expert is a person who is specially skilled on a subject. He is called expert. Person who is specially skilled in a subject, the court takes the help of the expert to decide matter on which court has no expert knowledge. Interstate succession also you to a person who died without executing a will valid will, that is the succession takes intestation. Will is a declaration by either declaration that who will take property of a person after he, that is a declaration. Right to collect land is an immovable property. For that, when that is for that a registered document is benefit arising out of the land. That is also when lac is collected, not for a particular period, but from time to time, it has the right to collect. Afraid two or more person fight in a public place, disturbing public peace. That is all. Abduction. On the other day, I had also told you what is abduction. Whoever by force, first by takes by deceitful means, force deceitful means, induces or takes any person from one place to another, that is abduction. Conviction rape case is if the victim evidence is believable, then conviction can lie solely on the testimony of the victim. That is move on. Dowry death. If a married woman dies within 7 years of marriage in a suspicious circumstances and soon before her death, this is what you have to. She was subject to harassment for dowry, then that will be treated as dowry death. This is dowry death. Then transport policy also, 300 you answered it. Why as a committee, if culpable homicide, by committing culpable somebody or just death of another person who death he had not intended, that is transport policy, that will be either murder or culpable homicide, considering the facts of intent, death of another. Cucumber also you answer fish, real fish, because when a fish came out of the tank, that is property of nobody. Nobody is under nobody's possession. So theft is not there. Then cucumber also the dishonest intention is not there. Causing wrongful gain, wrongful loss. No. You paid the price and went away. That is writing or force or violence is used by what, members of the unlawful assembly or in the unlawful assembly. That is right. Now you are doing well. So some conceptual clarity must be there at the time of giving your answer. Be prepared for it. You are doing well, but sometimes you are unable to express your that thought. Try to take care of this. Thank you.
So,
So, I mean, my suggestion would be you are using a word, particular word, however, repetitively, right? So, message goes is like if you are not very confident or you're trying to somehow manage the answer, that's why you use however, right? So, sometimes you are giving the answer, then your next line is, I don't know, it may be the answer. I was like to a lot of question to which sir was asking. So I would request you to avoid those. If you know it, tell it. If you don't know it, say I don't know. And if you have confusion, you take a call that how much sure you are. Then you answer. Okay. So that it would be like you know certain things and certain things is not in your memory. That is all good. But when you answer, then you say, however, this could be like this. It probably it looks like even if it is correct, the message is probably the candidate is bluffing or maybe trying to somehow manage, right? So I would request you to avoid that. Rest, you have prepared the statutory provisions. You know the basics. Only thing is that uh, you may be like in acknowledge of liability. You said specific relief and then you said limitation. So you said both.
is that both?
Okay.
Then
Yes. Okay.
maybe I
So
got
just
nervous or
if you're
something.
very sure, tell it, but don't use however again and again. Okay.
Oh, oh,
Rest. All the best.
thank you,
Best
sir.
wishes. God bless you.
Thank you, sir.
It's a fine. There cannot be excessive fine. So unlimited is
Yes,
there,
sir.
but fine must not be excessive. And reasonable level.
Okay,
In fact, sir's feedback being noted by me. Sir, thank you. It is helping us also. We are noting it.
Okay.
okay, sir.